straight ahead on Law and Crime Daily. The Kenosha shooting suspect's defense loses their motion to dismiss charges. Kyle Rittenhouse is now bound for trial.
A teenager in this case killed 2 people and shot a 3rd because teenagers shouldn't be allowed to run around with dangerous weapons because bad things happen.
Prosecutors argue cameras shouldn't be allowed in the George Floyd trial, but is that fair? Our experts weigh in.
Plus, the FBI needs your help identifying this mass bank robber. The Too-Tall Bandit strikes again. Law and Crime Daily covering court cases along with Terri Austin. Lawyers for the accused Kenosha shooter failed to get 2 of his charges dismissed. Kyle Rittenhouse is accused of fatally shooting 2 people and wounding a 3rd during protests in August. Rittenhouse was released from jail on a $2 million bond. He's facing 6 charges, but his lawyers wanted 2 dismissed: possessing a weapon while under 18 and recklessly endangering the safety of a journalist when he shot at one of the victims. They claim there's no legal argument for either charge.
What the government is trying to seek is an impingement of my client's Second Amendment rights, which is not covered by this statute. It's very specific regarding when it's a misdemeanor, what it applies to, and there's basically 3 prohibitions, none of which are met. There's nothing in the criminal complaint that says Mr. McGinnis was in the line of fire. There's nothing in the criminal complaint that says he feared for his safety. There's nothing in the complaint that my client recklessly, intentionally, or otherwise pointed the gun at Mr. McGinnis.
Richard McInnes is a journalist who was covering the August protests for the Daily Caller. He says he saw Rittenhouse turn towards Joseph Rosenbaum and shoot.
McGinnis described the point where the defendant had reached the car. McGinnis described that the defendant had the gun in a low, ready position, meaning that he had the gun raised but pointed downward. The butt of the gun would have been at an angle downwards from the shoulder. McGinnis stated that the defendant brought the gun up. McGinnis stated that he stepped back and he thinks the defendant, this is at the top of page 4, he thinks the defendant fired 3 rounds in rapid succession. McGinnis said that when the first round went off, he thought it hit the pavement. McGinnis felt something on his leg, and his first thought was wondering whether he had gotten shot. McGinnis was behind and slightly to the right of Rosenbaum in the line of fire when the defendant shot.
The judge ruled in favor of the state, so the charges will remain.
In this case, when you discharge, or it's alleged that this defendant discharged a firearm in a crowded urban environment, one could argue that's inherently dangerous nonetheless. Issues whether or not that was in self-defense or otherwise are for trial, obviously. With respect to the issue of whether or not, in this case, Mr. McGinnis was endangered or recklessly endangered, that's, again, an issue for trial. When you have in the complaint sets forth reasonable inferences that this defendant discharged a weapon that Mr. McGinnis thought it hit the pavement. Okay, well, as most people know, when a bullet ricochets, you never know, for the most part, where that bullet's going to ricochet to, or what trajectory the bullet takes.
Then, court moved to a probable cause hearing, and the defense questioned the lead investigator over who fired the first round.
The video begins with an individual by the name of Mr. Zeminski telling Rosenbaum to get or kill my client, Mr. Rittenhouse, correct?
I have not heard that line, and I definitely could not say with certainty that I heard Mr. Zeminski saying that.
Okay, did you hear Mr. Zeminski give Mr. Rosenbaum some sort of direction before he began chasing him?
No, I have not.
Mr. Zeminski fired his gun while Mr. Rosenbaum was chasing my client, correct?
Objection, relevance.
It's relevant. It goes to the events in question of how it was Mr. Rosenbaum became shot.
Your Honor, we're getting into what I know the defense wants to do today, which is make this a self-defense case. And as the court has already indicated, that's an issue for trial. What happened before this incident, what happened with regard to Mr. Zeminski is beyond the scope of this prelim. It does not go to the probable cause as to whether or not the defendant committed a felony. And I object to the relevance of this.
I'll tell you what, I'll overrule on this question, but again, I'm going to keep a tight rein on it, Mr. Richards.
My client in Exhibit 2 is running from Mr. Rosenbaum when a shot is fired by Mr. Zeminski, correct?
Correct.
All right, Terry, so let's break this down. 2 arguments denied. What did you think about the judge's ruling that those 2 charges of reckless endangerment and possessing a gun under the age of 18 should stand?
The judge absolutely made the right decision here, Brian, because reckless endangerment involves a substantial risk of serious injury to another, and he's disregarding the consequences. And the judge actually said, when you hit and something hits the ground and ricochets, you should know that it could injure someone. So I think he definitely made the right decision as far as that's concerned. And as far as the gun possession is concerned, while he might have been able to possess a regular shotgun or rifle, he wasn't trained. And I think the state was correct when they said, without the training, you are breaking the law.
Now, they're arguing this whole who shot first in a probable cause hearing. We heard the prosecution argue that's not the right place, but it seems like there's the self-defense argument to be made here. What do you think of that argument so far?
Yeah, I think that's all they have. They can't argue that he was defending property, whether it was his property or someone else's property. And I do think that is something that should remain for the trial to decide. But, that is the only claim I think Rittenhouse can make, is that he thought his own life was in danger. And so he was acting in self-defense there. And that's what they were trying to claim.
Of course, and let's be very clear, it's a procedural issue here. Self-defense is still on the table. It's just not the right place or time to be making that argument. Thanks, Terry. Still ahead on Law and Crime Daily, a Florida sheriff calls a librarian's death a senseless tragedy. How one mother died protecting her son. But first, an update in the George Floyd case, why prosecutors are fighting against cameras in the courtroom. Our legal analysis after the break. Welcome back. Prosecutors in the George Floyd murder case are appealing a judge's decision to televise the trial of the 4 former officers. Derek Chauvin, Too-Tall, and J. Alexander King and Thomas Lane are scheduled to be tried together in March. They're facing murder charges for the death of George Floyd this summer. Minnesota State Attorney General Keith Ellison's office is handling the case. He called the judge's decision to allow cameras in the courthouse not only ill-advised, but also illegal without their consent. Law and Crime contributor Elura Nanos criticized the prosecutor's motion, saying the trial should be televised in its entirety. Elura Nanos joins me now. Elura, I read your article as I was walking my Dobie this morning and thought, I've got to have her on. You countered Ellison's arguments point by point. Walk us through some of them.
Okay, so he argued that under the criminal procedure code in Minnesota, that both sides have to consent and the witnesses have to consent in order for it to be okay to let cameras in. So the judge said, no, that's not what happened. That's not the way it works. And here the public interest is so strong in having coverage of this trial gavel to gavel that there's absolutely no reason in the interest of justice that there should be no broadcasting. And Ellison brought up a number of other points. He said that this could be dangerous for witnesses or it could be bad for the prosecution, but really just none of those were compelling. And what came through is that he just felt more comfortable as a prosecutor to not having cameras there. And I imagine that the defense attorneys feel the same way. In fact, I'm sure all the attorneys are thrilled not to have cameras in there. But the judge said, sorry, I'm ordering that there's cameras in the courtroom. And really, in this case, almost more than any other case I can think of, demands media coverage.
And I guess that's really the question, because as a public defender and defense attorney myself, I'm thinking, as much as I like the camera, I don't know if I want it there during a trial. Do you think too much of a good thing can be a bad thing here in this trial of televising it?
No, I don't. I think that there's only a downside to not televising it. Now, I'm not suggesting that it's going to be welcomed by attorneys on any side. No one likes having their work put under a microscope. They know what they're in for. They know they'll be the subject of public critique in success or in failure. So I understand that and I sympathize with that argument. The problem is there's a stronger argument. And the stronger argument is that this case that captured national and international attention demands that the public see what is going on, see the evidence for itself. hear what people have to say, and understand in as much of a detailed way as possible. Otherwise, if we get it only through the filter of media, only through the filter of attorneys, it just has so much more potential to inflame an already inflamed situation that no good can come of it.
And that was the point that really grabbed me when I read your article. The fact that this is such a unique case, that there was actually a global movement, not just for a state or a country, but a global movement in the death of George Floyd. Do you think that uniqueness is what's really pushing to have the cameras in the court?
Well, look, yes and no, because I'll say that there are many, many cases that cameras do in fact belong in courtrooms. There are times when cameras can be a distraction, but with the advent of better technology, that's really not so much the case anymore. I will say that this case, if there were ever a case, demands media coverage, but there are many cases that also demand media coverage. I don't think that this is a standalone situation, but I do think that this is an extreme example of a situation where it would be a terrible mistake to shroud it in secrecy and make the American public watch it only through the filter of media coverage, when really what is needed is for people to be able to watch and look and analyze for themselves to really understand what happened in this case. I think that that's the only way for the public to heal over the tragic death of George Floyd. And I think it's the only way for the public to really understand what will be done to prosecute the offenders and how fair that case hopefully will be against them.
Right. Elura, I tend to agree. And hey, if Law&Crime wants to send me there to cover the case, I will, of course, do that because I want to see it myself. Thank you, as always, for joining us. Always a pleasure.
Thanks so much, Brian. See you soon.
Yeah. Now, Terri, we've been talking about this, and it's kind of awkward for you and I because we're both legal analysis on a TV show, Law&Crime Daily, but we're also lawyers, so we've got these kind of two-hat thing. Where do you fall in this as to whether or not George Floyd's case, or just a trial, should be televised?
You know, there's no question in my mind this should be televised. I agree 100% with Elura. I think obviously the Sixth Amendment says the defendant has a right to a fair trial, but it also means that the public has a right to see what's going on. You know, the late, great Gil Scott-Heron said that the revolution will not be televised. And what he meant by that was that change comes through action, not through complacency. But ironically, I think here, the revolution must be televised because we have to have access to what's going on. This is such a big case. It's bigger than just this one individual. So yes, I definitely think cameras should be in the courtroom.
All right. There you have it. Both Elura and Terri agreeing that we should have cameras in there. Thank you very much. Coming up on Law&Crime Daily, prosecutors attempt to retry a woman in a murder for hire plot, but COVID-19 concerns cause more delays. Plus, he might be large in disguise, but the Too-Tall Bandit has struck again. I don't know how, but the serial bank robber dubbed the Too-Tall Bandit is at it again. The FBI says the suspect has eluded law enforcement for at least 11 years. After a 2-year hiatus, he apparently hit 2 banks in North Carolina last month. The FBI released this surveillance video showing the armed bandit in hopes of someone recognizing the robber. Agents say he's about 6 feet 8 inches tall, weighs 250 pounds, and has a limp that affects his right leg. He's believed to be responsible for holding up 16 banks and a pharmacy.
A Florida mother run over by teens while defending her son has succumbed to her injuries. The Polk County Sheriff's Office says Suzette Penton died 2 weeks after being hit with a van. Penton was reportedly helping her son because his ex-girlfriend and her friends came over to beat him up. The sheriff says the teens retreated to their van when Penton went outside. She was trying to take photographs of the van as it fled.
Elijah Standstill runs over her, completely over her. She has tire tracks on her body where he runs totally over her. As we speak today, Detective Fulcher from our homicide team is on his way to the South County Jail where he's still locked up to charge him with murder.
18-year-old Elijah Stansell is facing charges of first-degree murder. The 3 teens involved, ages 14 to 16, will be charged as adults.
Unneeded tragedy. Thanks, Terry. What are your thoughts on charging these teens as adults in this case?
You know, Brian, I think that is absolutely the right decision. This was an intentional act. It was caught on camera. And if in fact it's a very serious crime, which this is, they can be charged as an adult. So I think the judge made the right decision here, and they should not get away with what, in my mind, was an intentional attempted murder, which ended up in an actual murder.
We'll make sure to continue to follow this case. But when we come back, a deadly murder for hire plot remains unsolved. When will one of the defendants face trial for a second time, and what's getting in the way? In Florida, coronavirus concerns have delayed yet another trial we've been following on the Law and Crime Network. A jury was hung during Katherine Magbanua's first trial for first-degree murder. Prosecutors say she was the messenger in a murder-for-hire plot against victim Professor Dan Markle. Her co-defendant, Sigfredo Garcia, was convicted and sentenced to life in prison. The Leon County, Florida courthouse is closed to the public, and jury trials are on hold due to rising cases of COVID-19.
It's a fluid situation, as you all know. We don't know what the criteria will be in January. In all likelihood, I don't think it will be met in January or February. I think our next opportunity moving forward to get this set will be in March, quite frankly. On the March 4th case management, we'll be at a time where we'll be able to get something firmly set so that we could move ahead with a jury trial in this case and at least get a date set. So not on that date, but in the future from that date, we'll know more.
Her attorney said at trial that she was wrongfully dragged into a conspiracy through an FBI wiretap by her then boyfriend, Charlie Adelson, who was the victim's brother-in-law.
The bump gave him the idea to use Katherine as a buffer. Find out who it is, call that number, knowing that she could say something wrong, she could do something wrong to incriminate him. The reason why he was so confident with having her call is because he knew she didn't know anything. But when Katherine wants to know, what is this about? The answer is, the less you know, the better. There's no information flowing in between there. There's only one reason why a single mother of 2 young children would sit in custody for 3 years in confinement, risking it all. She's innocent.
But prosecutors say Magbanua knew of the plot and want to prosecute her a second time.
This murder began with the failed relocation efforts when Charlie Adelson first looked into hiring a hitman. It took root when Katherine Magbanua enlisted Mr. Garcia, who enlisted Mr. Rivera, to do this killing. That planning went into the killing was extensive, spanning a 6-week period, including 2,000-mile trips made in rented vehicles, scouting out the scene, stalking Professor Markell, and all the planning, all the meetings, all the calls came to fruition when Garcia fired those 2 shots into Mr. Markell's vehicle and devastated so many lives in an instant. The Prius led to Rivera, Rivera led to Garcia, and the bad blood led to the Adelsons, and both trails end at Katherine Magbanua.
Terry, the judge previously denied a motion by the defense for Magbanua to be released on bail due to COVID-19 concerns. Could that mean she's sitting in jail indefinitely waiting for this trial?
Yes, and I think she should. Based on the prior trials that we've seen, there's so much evidence against her. I mean, she was one of multiple parties. Her boyfriend/husband, Garcia, the person that was hired to help, Luis Rivera, the Adelsons, the brother, the mother, they all were involved in this. And I think Katherine Magbanua is absolutely one of the individuals who should sit in jail and who should be prosecuted again as far as this case is concerned, because she had a lot to do with this plot.
So I got to put my public defender hat on here, though. She's not convicted. She's still presumed innocent. So if she's presumed innocent, why sit in jail during a pandemic, waiting for a trial?
Because I agree with you, but this is a very serious charge. This involved the murder of a professor, Markel, who was, attacked unknowingly. And I think that, COVID-19 is a serious concern and that people should not have to sit and wait for the trial. But this was a very serious crime, and I think she should sit in jail and wait for her trial.
Do you think there's any potential next steps for the defense to make? I mean, they were denied once. Is there any other thing they can do but wait?
I think if she had a serious illness or if something, about her health said that she should be able to sit this one out, then maybe. But other than that, I think she's going to have to get in line like all other defendants who are waiting trials for serious crimes like this. If this was robbery or some other crime that didn't result in someone's death, I would say let her out. But here, I think she should sit tight and wait for her turn.
Yeah, and this isn't unique to Magbanua. I can tell you, practicing in New York, it's happening all around. Terri, thank you, as always, for joining us here and lending us your aid. Thank you for joining us here on the Law and Crime Daily. We'll see you next time as we discuss justice in America.